Alright, welcome back to another episode of Law Schoolers, again talking about criminal procedure. This is the last subject that we have related to reoccurring searches. And what I want to talk about in this episode is search technology. This is going to be a revisitation of several cases that we talked about at the beginning. For instance, United States versus Jones when it comes to using GPS technology. Want to talk about the use of dogs, which again is a technology used for conducting searches. Also want to talk about searching phones and other electronic data and how you can pick up use technology to pick up whether or not people are in certain locations at certain times. So those are really going to be the three primary things of search technology that we talk about. Well, that's a good introduction. Let's go ahead and start right in with GPS technology. We have United States versus Jones. This is something that we talked about previously. United States versus Jones, what happened is that the individual was essentially a mob boss. I'm not exactly sure what the crime was, but they wanted to track Jones, so they issued a warrant. They put a GPS at the bottom of his car. This was outside the warrant, and they tracked him for 4 weeks. Well, our takeaways from United States versus Jones, just as I talked about then, the Fourth Amendment is going to protect people and places. This was not a valid search because it ended up trespassing onto the vehicle. If this action was done in the 1800s, it would have been considered a trespass, and for these reasons, attaching that GPS was unreasonable. The concurrence does think that the CATS test should have been applied here, and that is the reasonable expectation of privacy. It believes that there was a reasonable expectation of privacy. Majority didn't even get into it because there are some arguments of whether or not that would be a reasonable expectation of privacy or not a reasonable expectation of privacy, but this case reinstalls that trespass test. That test that was originally in Olmstead, that CATS overturned, but Jones reinstates that and says you can have either trespass or that reasonable expectation of privacy. Part of the problem here, in this case in Jones, is that GPS technology was pretty new, and the court needed to come up with a solution on how to handle GPS technology. And it seemed like the trespass test appeared more helpful, and it kind of put into question CAT's standing within the reasonable expectation of privacy analysis, and that is often conducted. GPS technology, just like other technology then, was new. There's new technology now. We'll get into that after I talk about dogs. We have a case here, Florida versus Ordinez. I apologize if that's pronounced wrong. But this is a case where the officers believe that the occupants of a home were creating drugs. They approached the door without a warrant. Instead of knocking, actually they did knock, but as they were waiting with no answer, they let the dog sniff around the porch, sniff around on that curtilage, and the dog ended up pointing to the front door to indicate that there was lots of evidence inside of manufacture of illegal drugs. This was something that is unconstitutional. And what is our rule here? Well, although people have a standard license to enter the doorstep, like to talk to the owner, there is no standard license to bring a dog with you. Most people don't expect you to show up with a dog. There is no standard license for a dog to search for drugs while on the doorstep. Again, you're within the curtilage. Although the police officers have the ability to approach the door, that's within their right, they can't do it with the dog for the purposes of conducting a search, because if you're doing that, you're trespassing. It's going against the curtilage. And so this is kind of a furtheration of Jones, an application the trespass doctrine to determine whether or not this was a search. The concurrence in this case says that the use of a dog is a highly specialized tool, kind of like a metal detector, and therefore is outside the scope of being allowed on the doorstep to conduct a search. I personally think that's a better argument than the no right to bring a dog on the porch, because, I mean, if you've got a blind person who requires to service a dog and they're coming up, well, then they're not trespassing just because they're using a dog to guide them on their way to the porch. And so I think that the use of a dog is a highly specialized tool for the purpose of criminal investigation, and that is what would have made it outside that scope. The dissent here does argue that dogs are an integral part of society, and dogs have never been discussed in case law as a trespass. It's never been a trespass to take a dog onto somebody's property. In other words, the court's ruling is a novelty in saying that dogs can't be on the porch if that person is a stranger. So, although dog searches are fine in the context of luggage at the airport, and dogs are fine when it comes to traffic stops, and they're not fine when it's within the property of the home around the curtilage. And again, we see here that the home is a special place where they have the most Fourth Amendment protections. There is a question, though, of whether or not you can take a dog to an apartment and whether or not that is going to be considered a home. That is a case on point there is Burns. It's still kind of just an open question, state by state kind of analysis. Okay, let's talk about phones and other electronic data. We have Riley versus California. What happened here is that the officers obtained thousands of pages of information related to phone data that was stored. So when you use your cell phone, there are several satellites and several service storage points where it is able to collect the data of when you're using your phone, how you're using your phone, so on and so forth. And so the officers in this situation had requested that information from the phone company, and that information was provided. And it tended to prove that Riley in this situation had committed a crime. Under Schimmel, a search incident to arrest can occur because, so in this situation, they were able to do a search incident to arrest to avoid, to protect against the officer's safety. And the standard there is going to be unreasonableness to see whether or not that search was unreasonable. And to determine whether or not the search is unreasonable, the court is going to balance the government interest against the nature of the privacy interest of the subject. Well, what's the government interest here? The state is going to argue that phone presents safety and destruction of evidence concerns. The court here is going to reject that argument. They're going to say there is no safety concern because the phone is not used as a weapon, and the digital data is not an immediate threat to life. And additionally, the destruction of evidence concerns are not going to be viable because there are methods of excluding remote access to a phone. This is by putting the phone in airplane mode or Faraday bags. And there are no exigent circumstances such as an emergency that may merit the search. Without those exigent circumstances, a warrant is going to be required to actually conduct a search on the data of a phone. Now let's look at the privacy concerns of the individual. Well, the prosecutor here is going to argue that the privacy concerns are lower because the person is under arrest. The court again disagrees, though, because a phone contains so much information about an individual, and that kind of information is the same kind of information you're likely to find in your home. Your communications with private individuals, pictures that you might have in your home, so on and so forth. Those things are more protected, more private, and for those reasons, there are several privacy concerns on a phone, and that the data should not be able, that the officer should not be able to access the result of this case is that the search here was unconstitutional of the phone. The current concurrence does agree that the search was unconstitutional, but only because there are no better options for conducting the search. Instead, the concurrence argues that the best way to resolve the issues of data analysis and searches is going to be through the legislature. So what is the result of this case, Riley versus California? End result, you need a warrant to search a cell phone unless if there is a classic warrant exception. What is a classic warrant exception? It's going to be an exigent circumstance. The primary exigent circumstance here is if you are looking for a victim and evidence about the victim's location might be on that phone. That is going to be your primary exigent circumstance when it comes to searching a phone. Okay, we've got two more cases. Carpenter versus United States. This is also an interesting thing because, again, these service providers, they can track the location of your phone several times in several places. Here, Carpenter was suspected of being involved in robberies, several robberies, and the officers wanted to obtain information related to where Carpenter was at the time of the robberies. Well, phone and location records based on phone use is going to constitute a reasonable expectation of privacy where a warrant is required to obtain that information. Now the question is this going to be based on the trespass analysis, or is this going to be based on the reasonable expectation of privacy? Ever since Katz, there was the expectation of privacy standard. The standard, however, is going to be mitigated by Smith, by Miller, by Jones, which says that there is no reasonable expectation of privacy for records that you provide to third parties. Here it's argued that the cell phone carriers are third parties, and you are providing that material to those third parties, so it should be obtained. The court is going to refuse to extend this third-party guarantee to the carriers. This is because phones have an expectation of privacy that is similar in Jones, and that is a trespass. People expect to be secure in knowing where they are traveling, when they text, what they text, who they call, and when they call. Additionally, the only way to avoid giving the information to a company, a third party, is by not using a cell phone at all. So it can be hardly said that the information is voluntarily given. So in other words, you have a reasonable expectation of privacy, so you can't search the phones by the third party carriers. On the other hand, if you're the Kennedy dissent is going to argue that a third-party record is still just a third-party record. And because it's a third-party record, it clearly falls within the standard of Smith and Miller, and it should be readily admissible at trial. The Gorsuch dissent doesn't like the third-party argument at all, and instead wants to state that the defendant waived the better argument, and that is by discussing property rights, trespass rights. Trespass rights wasn't discussed at all. It was just reasonable expectation of privacy. And because that should have been the argument that was made, that should have been the argument that should have won the day, but it wasn't made, so it should have been admissible because the other argument isn't a very good argument, the argument of the reasonable expectation of privacy. Okay, one last case, State versus Russo. Well, the officers suspected that Russo was abusing prescription drugs, so they went to several pharmacies and asked to see the records that Russo had provided to the pharmacies of obtaining those prescriptions. The pharmacies provided those documents, and those documents were used to convict Russo of possession of a controlled substance by forging prescriptions. Well, in 2002, the court held that this was not a search after doing a balancing test, the balancing test of that we talked about in Riley versus California, the state interest and the privacy concerns. And essentially, this is going to be a third-party waiver doctrine example where prescriptions provided by pharmacy is going to be subject to search because it's being made by a third party. All right, that's everything as far as search technology goes. We talked about GPSs, we talked about dogs, we talked about phones and other electronic data, and we talked about the third-party doctrine and ultimately this idea of trespass versus the reasonable expectation of privacy and which standard is kind of going to win the day at the end of the day. And it's still up in the air. We don't really know 100%, but we do have a feeling that the reasonable expectation of privacy test is around to stay for a while, and then the trespass test is an interesting way of handling these kind of issues as well that has not been addressed. Well, that's everything. I'll talk to you guys later. Have a good one, and bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.